Hello everybody, so welcome back to the English law channel. So I'm carrying on with tort. So this is about private law, personal wrongs, and it overlaps with criminal law, as I was saying, because a crime is against the state, the whole community, and criminal law is there to punish the criminal. Tort is different. It's not mainly about punishment. It differs from criminal law in as much as it's not focused on the interests of the public as a whole, but on the individual who has suffered the tort. So tort law and criminal law, they have something in common, is that they are managing conduct, and they're setting permissible standards of behaviour and declaring certain actions to be impermissible. However, where tort law again is dissimilar to criminal law is that it's not about introducing abstract standards. There's liability in tort, and this is usually predicated on someone proving that damage has been suffered. A person isn't liable in the tort of negligence if he drives down the wrong way down a street whilst inebriated and whilst disqualified from driving. He's only liable if this results in damage. All the other things he did were criminal, but they're not tortious. Someone could be liable in the tort of negligence if this sequence of events leads to damage to another person or someone else's property, or indeed even to economic interests. Though pure economic loss is difficult, it isn't usually compensable. But if no damage has been sustained, it's still a crime, but it wouldn't be a tort. So things can be tortious and criminal at the same time, for instance public nuisance or indeed battery. So also damage, that's a key element of tort. In tort, a materials damage has been demonstrated where there's an action and there are rules about which losses are recoverable and about the irrecoverability of certain other losses. Usually, unless the claimant can demonstrate that the defendant's tort resulted in the loss, then the claimant's action will be defeated. So the claimant has to demonstrate a sufficient cause and effect relationship in order to claim successfully. The damage might be regarded as too remote, in which case it's not recoverable. Anyway, so tort can be actionable even if there is no damage suffered, but that's rare. There are some unusual instances if there's intentional or negligent conduct, and that's actionable without the damage. And here the claimant's rights might have been trampled on, and there might not be a requirement that damage be proven. For instance, if this is subject to numerous defences, but it's an actionable tort to intentionally touch another person. This is called trespass of the person, even though no damage arises. And in these cases, the tort is actionable per se, that's to say, by itself. The interest of reputation, remember, is safeguarded by defamation, and that's also strong. The tort of defamation, remember, is actionable per se. So if you besmirch somebody's good name in publication, through writing, or on broadcast on the radio, television, internet, things like that, or printed material, then that is actionable, even though no damage needs to be demonstrated. Okay. Now, not all damage is compensable. If somebody sustains harm or loss owing to another's tortious act, it could be that the damage that is suffered is not of a nature that the law will compensate. The issue of the type of damage the law will recognise is central to torts, and there's some legal argument I'll come to in a later video about that. Claimants in tort can suffer many different wrongs. But to see the defence in intentional or careless behaviour has to cause the damage. That is the loss, the physical injury, or whatever it is. And it has to be loss of a kind which is recognised in tort. People who claim to contract diseases because they've been exposed to noxious substances, or that they claim that they suffered an economic loss due to negligent advice, they might claim to have suffered some psychological harm or emotional illness due to some malicious communication. But as medical science moves forward and information technology, developments in work technology, and the way that business enterprise functions differently now has caused the number of types of losses to burgeon, and a person might be exposed to numerous different types of tortious conduct. So law is a living instrument. It's forever evolving, particularly in tort. There are different kinds of tort which are recognisable in tort, and here's just a few of them. So, for example, Okay, so physical damage to a person or his or her property could be a psychological harm arising from physical harm or apprehending that some bodily harm is going to be sustained, even if it's not actually sustained. Someone interfering with your real property, there could be economic loss. So some types of damage, like physical injury or damage to property, in the law is quite clear about this, about the forms of damage which lead to an action in tort. Of course, there has a number of qualifications relating to liability. There are different kinds of damage which are altogether outside the ambit of this tort law. But anyway, so in between complete inclusion, complete exclusion, there's a state of indeterminacy where it might be tortious or it might not be. So there's this intermediate category of damage where claims are only permitted once the claimant has reached a certain threshold of proof. So it's this indeterminacy, this zone of indeterminacy, which is the most challenging and scintillating. So what sorts of damage are actionable? So there's a lot of case law about this, and this can be very tricky and intricate. So there's a sort of hierarchy of interests which are safeguarded by tort, physical injury being the highest, and below that are various types of damage to property, there's psychiatric health, and there are other categories relating to negligence actions. There's breach of privacy, there's misuse of private information, and these leads to specific kinds of damage. So there's a hierarchy of interest, and there are four overarching principles which judges usually declare to be applicable. So one is the loss or injury from natural causes is usually beyond the scope of court. That seems to go without saying. But we're talking about tortious damage. There's Stapleton's article on this in Disease and the Compensation Debate 1989. It's about how non-traumatic injuries, diseases, are less likely to be compensated in tort. And that's not because this is specifically prohibited, but because non-traumatic injuries are outside this conceptual framework of tort, which is because there's this very fraught and vexatious distinction which is drawn between man-made and natural causes. If it arises from human negligence or malice, that's different. But if an injury is said to come from natural causes, as it's a disease, it's not occasioned by accident, then the usual principle is that loss should lie where they fall. If you're unlucky, you got the disease, tough, that's your problem, you're not going to be compensated by somebody else. Unless there is an overwhelmingly convincing reason why that loss should be shifted onto a tortfeasor. So usually there's no damages are recoverable for disease. Now, by stark contrast, traumatic injuries, those we can say this happened at precisely this time and precisely this place, those are usually compensated. Okay, so other principles, injuries or losses for a traumatic event, for instance a car accident, or due to somebody falling through the roof or whatever, these are types of injuries that the tort privileges above others. These injuries are compensated in tort because the court sees them as more deserving of injury and just occasioned by human action or indeed inaction. There are types of losses, this is number 3, that are compensated within other categories of law, but are less likely to be compensated, and they're going to receive very little compensation in tort. For instance, somebody claims are suffering solely a financial loss due to somebody's wrongful or negligent behaviour, will have trouble proving a claim in tort because the law of contract is seen as the right area of law to deal with that. There are types of injury which are likely to impact on a very wide class, an indeterminate number of claimants, and that's problematic when it comes to compensatory matters, because injuries and losses should affect a discrete number of people for tort to be able to deal with them. Alcock against Chief Constable of South Yorkshire 1992, that's a leading case in this area. Okay, that's enough at the moment. Toodaloo.